help us understand a will versus a trust?
Sure. A will is a document that ultimately goes into a probate court and is an official statement that the person is making as to distribution of their assets in their own name, and the selection of representatives, usually an executor, sometimes a trustee under the will, if there are younger children under 18, a guardian. These are all very important decisions that need the formality and assurance of that formality in a document that the court can look at and approve. That's the will. A trust is a broader term. A trust can be established under a will. It can be set up during your lifetime as a separate self-standing document. It can be used for purposes of holding educational funds. Grandparents or parents can set aside funds for that purpose. Very broad legal concept, does not involve automatically a probate court, but can. The probate court has jurisdiction to hear problems concerning trusts. But very useful part of my practice in estate planning, the trust. And we often use trust to reduce or avoid the complications of probate, perfectly legally with the blessing of the probate court system. But property in trust, when one passes away, goes immediately to the beneficiaries, or perhaps held in trust for a further term for the beneficiaries, but without the involvement of the probate court system. So it's an alternative to a will, really, is a good way to think of it, and also has broader application during lifetime if you wish it to.
And there's revocable and irrevocable, correct?
Correct.
And
yes.
what do you recommend for your clients?
Well, I like the use of a revocable trust in most estate plans because it does give us the flexibility of allocating some assets to that trust and keeping them out of the probate process, which will save a lot of time and complication. Also very useful for holding out-of-state property. If you have an inherited vacation or family home, or you bought one, for whatever reason you have, even a timeshare can be real estate in some states. Those will trigger a second probate proceeding if you're not careful about it. If you pass away with that kind of an asset, of a real estate asset in your name in another state, you will have an ancillary or secondary probate proceeding in the other state. Use of a living trust, a lifetime trust, to hold title to that property is a way to avoid that, because the trust, unlike us, will not die. It may terminate, but it will not die. So the trust would continue to be the owner, even if we lose the person who made the trust. So very handy for that purpose. We use irrevocable trust, the other version that you mentioned, to achieve a tax planning objective. For example, life insurance can be placed in an irrevocable trust and moved out of one's taxable assets. There are some catches. You have to survive 3 years beyond the date of the transfer. And life insurance is particularly useful because it has very limited, if not zero value when you transfer it in, but high value if and when it comes into effect with a loss. So it's a way to move all of that asset value out of your name and into a separate vehicle, an irrevocable trust for your family that you control through family members being involved in management. So irrevocable trusts can be used for that purpose. We can also put other kinds of assets in irrevocable trusts. But remember that a transfer to an irrevocable trust is a form of gift, so that we have to contend with gift tax laws and limits and taxes that can kick in with that kind of planning, with gift-oriented planning. With a good professional, you can overcome those concerns and know what you're getting into and what you're achieving. But that's my main use of an irrevocable trust, is for tax planning.
Okay. So if you have clients who don't have a will, or don't have a living will, or don't have any of their assets in a trust, what do you recommend? I mean, especially now, what's your counsel? If there's people listening who have none of that.
At the very least, put a simple will into effect. If nothing else, you can choose guardians for your minor children, and you can avoid what they call the probate bond requirement. A probate court is required to impose a fiduciary probate bond on every estate that does not specifically waive that requirement. There are some exceptions. The judge can independently determine that the bond is not necessary, but why take a chance? So it's so easy to sign a simple will, preferably with the help of a professional. There are some canned wills out there I'm not a big fan of, but they do exist. But you can easily appoint a guardian, waive the bond requirement, and also indicate your choice of executor, the person who would be in charge of managing your estate. And finally, if you have children, even adult children over the age of 18, if you don't think they're ready to handle all assets without some help, you can include a trust for them, perhaps up to age 25 or 30. Many of our clients worry about early first marriages maybe not working out, which statistically is the case. Mm-hmm. And you can help your children by not releasing funds to them, certainly not at age 18. I think that personally is too young, but it is permitted by law. They would be legal adults. So yeah, at least a simple will. Now, that's my minimum recommendation, but I would prefer people coming in to adopt. We have 5 documents that we like to recommend for new clients coming in for estate planning. One is a power of attorney, a durable power of attorney. That's a lifetime document, but it's quite handy if there were ever an accident or an illness that made it impossible for you to carry out a necessary action with an investment, a bank account, an insurance claim. Even things broader than that, access to files, dealing with your cable company. This allows you to appoint someone who can act while you're living in your place, sign your name, and take action for you. There is a duty of fiduciary responsibility involved, so you must act in your best interest, but it's a handy document to have, particularly recommended for people with elderly parents, people getting up there in age at least, because things happen, and it's just very useful for someone younger in the family to have that capability. So power of attorney, document number 1. Document number 2, healthcare proxy. That would allow you to appoint someone to make medical decisions, even in a short-term context. If you're under anesthesia or in an operation and something comes up that needs decision, multiple options for surgery or treatment or prescriptions, that person can be your voice while you're not able to make your own decision, rather than leaving it to doctors you don't know. They can seek the advice of the doctors, but at least you have someone who knows you involved for you. So that's the healthcare proxy. In that same form, we usually do include the living will we talked about earlier. There is a combined form available to us in Connecticut that's quite good. So we would include that living will in the healthcare proxy form. The third document we like to see is a HIPAA medical file access authorization form. The HIPAA laws, federal laws protecting the privacy of health information, are quite strict. The doctors are all aware of them. They will not share information with even other close family members. The spouse does not have a right to medical information on his or her spouse automatically. But with a HIPAA authorization form properly prepared and signed, we can open that door to them and avoid a stonewalling situation. We usually include spouses, at least adult children. Often now we include teenage children or younger, but perhaps restrict their access to verbal information only on status and condition. Handy thing to have. Now you can always, on an intake interview with a hospital, provide them with a list of names that you're okay with having access to information and communication. But if you don't have a chance to do that, you're traveling, there's a 911 situation, this document is critical to avoid that very difficult situation. And it's very common now with parents of college-age children. They won't think about these things. Something might happen in the campus hundreds of miles away, and the parent will not be told what's going on because the child is over 18. So we have a lot of parents of college-age children coming in just before the first semester begins, asking for those documents for their young adult children. Suddenly they're adults with their own independent rights, and it's an important thing to get ahead of. So that's the third document, and the last two would be the simple will, sometimes not so simple depending on the situation, and the revocable living trust. We increasingly recommend that. It's not absolutely necessary, of course, but it's a very handy thing to have to reduce complications of probate. Also to have available as a beneficiary for life insurance and IRAs, 401k plans. You have to be careful because there are strict rules with IRAs and 401ks about what a qualified trust must contain, but we address that in the trust document we use. And it does avoid the situation of having an 18-year-old suddenly coming into a lot of money with no management structure around it, because with use of the living trust as the beneficiary, we have an older, usually family member trustee looking out for the child and managing that fund until they're of the right age that you have decided is the right age of maturity. Often we'll see installments, maybe a third at 25, another third at 30, the rest at 35. Those ages are all arbitrary, the fractions are arbitrary, but each person has a pretty good idea of what makes sense for them. And of course, with the living trust, revocable trust, you can amend it as time goes on and you see the child develop. So just to recap, the 5 documents: a durable power of attorney, healthcare proxy, HIPAA authorization access form, the last will and testament, and the revocable trust, sometimes called a living trust. Those are the key documents I consider to be very important for anybody with any kind of asset base, planning their families and their own future, and just being on top of this. I like to comfort people by reminding them these are not documents we plan to use tomorrow. This is not our plan A. They're what I call umbrellas in our legal closet that are there for a rainy day we hope is not going to come around for quite a while, but you'll be very happy that umbrella is there if you need it.
Right. Frank, that was such a great, thorough answer. And as much as we don't like to talk about it, we do have a beginning and an end. And
Yeah.
we need to prepare for that. So, thank you so much for that answer. It was so thorough. I took notes. So I appreciate that.